We're tracking a major legal situation unfolding in Washington state that has serious implications for folks who care about the right to keep and bear arms. The case involving Gator Guns isn't just another courtroom fight, it's shaping up to be a pivotal moment that could redefine how the Second Amendment is interpreted across the nation. This isn't just a state issue. What happens here could set the tone for other states looking to chip away at our gun rights. At the core of the case is Washington's attempt to outlaw so-called high-capacity magazines and other firearm components. The state argues that only firearms commonly used specifically for self-defense deserve constitutional protection, an attempt to shrink a broad constitutional liberty into a much tighter, government-approved box. Gator Guns, backed by the Silent Majority Foundation, is pushing back hard. Their stance is clear. It's not the government's job to cherry-pick which guns or accessories qualify as worthy of constitutional protection, and that is the heart of this legal standoff. What makes this case especially concerning is the very real possibility that a majority of justices may side with the state. Even though Supreme Court decisions like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin have already laid down strong protections for arms in common use, the idea of public safety is being used like a wrecking ball aimed at demolishing decades of established Second Amendment precedent. If the Washington Supreme Court adopts the state's argument, this ruling could wipe out more than just magazine rights. It could also tear apart the legal foundation that protects firearms and gear widely owned by responsible Americans. There's a real divide on the bench and in the public between those who trust citizens to exercise their Second Amendment freedoms and those who think the government needs to control every piece of the equation. And make no mistake, the consequences of this decision are massive. This is not just political talk. If the court rules that Washington has the authority to ban magazines over a certain round count or worse, rewrite the definition of commonly used it sets a dangerous precedent. Other states could use this ruling as a green light to unleash sweeping bans of their own. Components many of us have legally owned for decades might suddenly be restricted, outlawed, or buried in endless bureaucracy. And here's the hard truth. Once a basic liberty is chipped away, getting it back takes a legal war of epic proportions. At the center of this legal challenge stands Gator Guns, a small shop fighting not just for its own survival, but for all American gun owners. Their lawyers, with the backing of the Silent Majority Foundation, argue that accessories like magazines are essential to the basic function of a firearm. That makes them protected under the same right to keep and bear arms. They reject the state's narrow definition that common use only means common use for self-defense. Instead, they say it should include all lawful purposes, whether that's sport shooting, collecting, competitions, or simply the enjoyment of firearms, just as multiple court rulings have already affirmed. If the court accepts the state's argument, it could open the floodgates for all kinds of bans. On the opposite side, the state's legal team, led by the Attorney General's office, insists that magazines don't qualify as arms and can be regulated under the government's authority to protect the public. They're also using language like particularly dangerous to justify these bans, a phrase that subtly but significantly shifts from the Supreme Court's accepted term dangerous and unusual. That change matters. Case law has only supported restrictions on weapons that are both unusual and dangerous, not commonly owned gear. Justice Cheryl Gordon McLeod, from what we've seen, appears to be the only one on the bench asking the tough questions. She's not buying the idea that the state can simply slap new labels on widely owned items and ban them outright. For those of us who believe the Second Amendment carries just as much weight as the rest of the Constitution, it's encouraging to hear at least one justice voice serious concern. The oral arguments that just unfolded before the Washington State Supreme Court felt less like a legal proceeding and more like a full-blown political theater. And for those of us who take the Second Amendment seriously, some of what we heard was nothing short of infuriating. The state made the claim repeatedly that so-called large-capacity magazines don't qualify as arms, nor are they crucial for any lawful use. On the other side, Gator Guns fired back with the obvious. If you strip a firearm of the ability to feed ammunition into its chamber, then what you're left with is essentially a glorified paperweight. A firearm without a magazine is like a car without fuel. It doesn't do the job it was built for. Throughout the hearing, the phrase common use for self-defense got dragged out so many times it felt like a skipping record. The state kept insisting that if a magazine isn't primarily used for personal defense, it doesn't deserve protection under the Constitution. That line of reasoning completely distorts what the Supreme Court has already made clear in decisions like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin. Self-defense is just one facet of lawful firearm use. There's also target shooting, hunting, competition, collecting, and yes, simply having a gun at home for peace of mind. All of these are legitimate purposes, and none of them should be discounted. One of the most stunning moments came when Justice Montoya Lewis bluntly asked, "Why do these people live and need these things?" That question alone revealed a troubling lack of understanding. The Constitution does not require any American to justify the need for an enumerated right. Can you imagine being forced to prove why you need freedom of speech or the right to attend your church of choice? That's not how rights work in this country. Then there was Justice Gonzalez, who seemed to get tangled up in federal code. He floated the idea that because magazines aren't classified as firearms under federal law, maybe they don't fall under the Second Amendment at all. That's a dangerously narrow view. Courts have long acknowledged that ammunition, training, and components essential to operating a firearm are protected extensions of the core right to keep and bear arms. What we're seeing here is the state trying to stretch and twist legal precedent to justify what amounts to a blatant power grab. They're swapping out the phrase dangerous and unusual, which the courts have traditionally used to justify bans on exotic weapons, for the much more vague, particularly dangerous. That switch isn't just semantics. It's a calculated move to label whatever they want as dangerous and toss it out of constitutional protection. Gator Guns, to their credit, did a solid job pointing the justices back to historical precedent and reminding them that, post-Bruin, courts are not supposed to use interest-balancing tests to sidestep constitutional rights. That said, there were a few moments when their defense team could have hit back harder, especially when justices leaned into the idea that broadening common use might make too many firearms legally protected. That was the perfect moment to bring up Heller, which affirmed that handguns are protected precisely because they are widely owned for lawful reasons. Justice Cheryl Gordon McLeod seemed to be one of the few voices on the bench that wasn't buying the state's narrowing of the Second Amendment. Her questions showed concern that reducing constitutional protection to only self-defense sets a dangerous precedent. If the defense had consistently capitalized on her skepticism, especially when the state slipped into interest-balancing mode, they might have driven the point home more forcefully. The Constitution does not allow the government to ban an entire class of arms that are in widespread use among law-abiding citizens. Ultimately, this hearing exposed the fundamental divide at the heart of the case. A state government eager to expand its authority over private gun ownership, and American citizens like us who believe the Second Amendment is not some second-tier privilege, it's a core part of our liberty. The stakes could not be higher. Unfortunately, many legal analysts are forecasting a grim result, an 8-1 decision in favor of the state, with Justice Cheryl Gordon MacLeod as the lone voice of dissent. That's a tough pill to swallow for anyone who believes that our constitutionally recognized rights shouldn't be whittled down by unelected officials or courtroom activism. The majority on Washington's High Court seems ready to embrace the idea that the government can toss around terms like particularly dangerous as a blanket excuse to skip over deeper constitutional scrutiny. A ruling like that would send shockwaves beyond Washington. If a state Supreme Court can declare that banning an accessory one that millions of responsible gun owners use daily is perfectly acceptable, lawmakers across the country will see it as an open invitation to push for more bans. People roll their eyes at the slippery slope argument, but in this case, it's not theoretical, it's a real and present danger. If courts start redefining what in common use means, or worse, allow states to selectively honor certain parts of the Second Amendment, we'll likely see wave after wave of proposals targeting not just magazines, but semi-automatic rifles, pistol braces, adjustable stocks, you name it. Just imagine what happens if a legislature suddenly slaps the label "particularly dangerous" on all modern sporting rifles. Never mind the fact that tens of millions of Americans own them safely and legally. What we're really seeing here is how difficult it is to fight back against these state-level power grabs, especially in courts where the judges already lean toward giving the government a pass. Realistically, it may take a decision from the United States Supreme Court to undo some of these rulings. But let's face it, not every small-town gun store or grassroots group has the resources to push a case that far. The bigger concern is that if Washington gets away with this, other states won't waste time copying the playbook. That's why national-level groups and constitutional watchdogs need to keep a close eye on these developments. If a one-sided decision from a high court implies that the government can chop away at the Second Amendment in the name of public safety, it sends the message that our rights are conditional, not guaranteed. It also highlights why we must stay alert to who sits on these state benches, because these judges wield enormous power over how our liberties are interpreted. Now, zooming out a bit, it's clear that this case is just one part of a larger pattern. Washington state has been rolling out new restrictions year after year: red flag laws, mandatory waiting periods, mandatory training courses, magazine bans, you name it. While each one may seem minor in isolation, taken together they create a climate where honest gun owners are treated more like potential threats than responsible citizens. The Gator Guns case sits right at the center of this larger push. If the state can convince a court to uphold a ban on standard magazines just by claiming they're too dangerous, then there's no telling what's next. Semi-automatics? Trigger upgrades? Adjustable stocks? Nothing's off the table. That's exactly why this fight matters. Because it's not just about how many cartridges a magazine holds, it's about defending the framework that protects our rights from creeping government overreach. Still, we're not powerless. There are concrete steps we can take: staying on top of proposed laws, showing up at public hearings, and demanding honest answers from lawmakers who want to regulate everything they don't understand. Supporting legal defense funds and advocacy organizations is also key. Those are the folks going to battle in court when our rights are under fire. And while national gun groups are important, don't underestimate the power of local, grassroots coalitions. Local pressure can make or break bad legislation before it ever reaches a governor's desk. At the end of the day, the Second Amendment is only as strong as the people who stand up for it. In a time when public safety is being used to justify every kind of infringement, it falls to us ordinary Americans to remind our elected officials that freedom matters too. If Gator Guns ends up on the losing side of a lopsided ruling, don't be surprised when other states try to follow suit. But maybe, just maybe, that moment becomes the spark that reignites our resolve. This could be the turning point that brings more gun owners together to push back harder than ever before. Before we sign off, I want to sincerely thank you for sticking with me through this important update. The road ahead isn't complicated, but it does require action, because if we stay quiet, you can bet the other side will take advantage of our silence. So do your part. Share this video with your fellow Second Amendment supporters. Hit that like button, subscribe, and click the bell icon so you don't miss the next big update in the Gator Guns case. Thanks again for watching, and I'll catch you next time.